I've read your motion, Mr. Wilson. There's a somewhat of a procedure to this. Obviously, Ms. Reynolds, CPS has been involved with your case, and Child Protective Services is not at this point allowing any parenting time. So his motion for custody is going to, I can't grant it. What I can grant is a hearing on it. Child Protective Services controls the case until they close their case. Mr. Wilson, have they indicated they would close the case if a custody change is made?
You
Ken,
talking to me?
yeah, Ken, Mr. Wilson.
Yes, they mentioned that the case is going to close, and they highly suggested for me to get full custody
Okay,
because if I did not and I wasn't able to keep Clara safe, they could remove
right,
her from me.
correct. Okay. So what I'm going to do is I'm not sending this to the front of the court or anything. I'm going to grant a hearing. Do you know when the next review hearing is for you?
Yes, it's 7/12.
Okay. Normally, did they indicate that they wanted this done before that hearing or?
They wanted me to, yeah, I believe so, have
Okay.
this done before that hearing.
Okay, because what I'm going to need is I'm going to need to hear from at least one of those workers at the
Okay,
hearing. So I'll need you to probably go to the Legal Assistance Center on the fifth floor of the courthouse and subpoena that person,
okay,
unless they're willing to just come. Ashley, what sometimes happens in these cases, depending upon if CPS is asking for that, the handwriting on the wall is that they're going to be limiting your parenting time in the future, and potentially, if things don't go well, terminating your parental rights. If the court switches custody and gives the father custody, then it'll close the CPS case, and then that deletes the ability of them to terminate your parental rights. So
Okay.
it actually keeps you safe. Now
Can
that
I ask
doesn't
you?
that well
Okay.
let me finish explaining.
Okay.
Then yes, I'll ask you to ask. I'll give you any
Okay.
chance for a question.
Okay.
But typically, what will happen then is we keep this parenting time suspended for a while, and then we'll slowly go back to parenting time when it can be done safely. But it actually stops them from terminating your parental rights. So it preserves some of that, but custody, if they deem it, but I'll need to have testimony from them and Mr. Wilson, testimony from you. This is a custody matter. So I don't know what your finances are, but you might want to go see legal aid or they've assigned an attorney for you in Muskegon, correct? For the neglect case?
you're talking to
Yeah.
Ashley, right?
Well, I'm talking to both of you. Have they,
No, I
I
didn't need
I
a.
have a public defender.
you have a public defender? Okay.
Mhm.
Who is your attorney in that case?
Elise, Elzinga.
Okay. Because, essentially, we're going to do a custody hearing. Technically, I have to treat both of you like attorneys. So you'll be given an opening statement, and then I'll need to hear
Mhm.
from witnesses, and the witnesses can be you. All right. So in other words, you can
Mhm.
call yourself, you can call the opposing party, and I'll need to know all that's going on and all that's been happening over the past few years. Okay. And then the court will make a determination on custody. But one of the people I'm really going to need to hear from is at least one of the workers or, whoever you deem a fit available to testify. Okay.
Okay.
And okay. Ashley, you had some questions, ma'am?
I sent in my
I
counselor
saw I
did a
saw I saw
review.
your response, and this court can't.
Hmm.
I can, even if I grant custody at this point in time, if Child Protective
Uh,
Services says the kid stays with whoever, I can grant you sole legal and sole physical custody. But if the child is removed by Child Protective Services and given to Mr. Wilson, he keeps custody. So that case overrides
oh,
anything this case does. I cannot order you parenting time or anything in this case. Even if I did,
mm,
they do not have to honor it. And what they're saying is Child Protective Services has grave concern. And I read the order from Muskegon. They are not even giving you parenting time at this point. So they don't want you to have any contact with that child.
and it
That,
is
that,
like
yeah.
so sad because um this is not exactly what that they're pushing, but I have to
Well,
do what I can to,
right.
you know,
And
it's frustrating.
this court will do what it needs to do. So I note you both live
Okay.
in Muskegon. So at some point, somebody may want to, for
Mhm.
both of your benefit, motion to have this case moved to another county. Normally, we don't just, it's not an automatic to move it to a contiguous county. But if you got all kinds of like Child Protective Services things happening in that county, and other things, it may be better to have the whole case moved there. But for now, Kent County has the case, so we will be doing the hearing. So we'll grant you a hearing on custody. I can't do anything with any parenting time or anything. And Mr. Wilson, just follow what Child Protective Services is instructing you to do. Okay?
Okay,
So we'll see you at that hearing, and please get one of those workers there.
yes. Do we
Okay.
have a date for the hearing?
Yeah, hold on. My clerk just said she does have a date. So let's give you that date here and now.
And you said it should be before July 12th.
Yeah, July 12th, because if the worker comes in and says, yeah, we need this done so that we can
Sure.
close their case, then I'd like to give them that opportunity instead of other, you know how neglect
I
cases
understand.
work. They'll have
Um,
another hearing in 90 days.
We can do Friday, June 28th, 9 to noon.
Okay. And question, I guess you guys are going to want that by Zoom, or do you want it in person?
I like Zoom
Okay.
to avoid the traffic in Grand Rapids.
I cannot blame you there. And both of you are in Muskegon, so that would be a lot easier for both of you.
Yeah. What was the time frame again?
9 to noon.
9 to noon. Okay, thank you.
And please, again, it would mean, because I don't think they have a legal assistance center in Muskegon, but the legal assistance center in Kent County and the courthouse on the 5th floor can assist you in subpoenaing a witness if necessary. And Ashley, the same applies to you. If you need any witnesses, you may subpoena them to come to that hearing. Okay?
Okay.
And Ashley, can we get you a better connection?
What do you mean?
Well, it sounds like
Okay.
your Wi-Fi connection isn't that good. So are you going to be able to get a
Yeah.
better connection, or?
Yeah.
Okay.
This video was okay. Sorry.
No, that's
Yeah.
okay. All right, just get a better Wi-Fi connection. If not, if you call my clerk, we can have you in person in the courthouse and have Mr. Wilson come by Zoom and all the witnesses come by Zoom. So if you can't get a better
Okay.
Wi-Fi connection, please let us know.
Yeah, that might. Okay.
All right, so contact my clerk, Miss LeVay. I believe you have the email for that because an email went out earlier. So, but if you can't get a better Wi-Fi connection, we'll have you in person, but let us know. I need to know. Okay?
Okay.
Okay.
All right,
Sure.
thank you. Because we
Thanks.
can bifurcate the hearing and have one person in person and one person by Zoom. So, all righty.
Yep.
Have a good morning. We'll see you on the 28th or whenever that was.
Yes.
All right, take care. 08718. Good luck.
All right, thank you.
Ms. Moore, you filed this motion. Is there anything that you would like to add to it?
Nothing that I'm adding, no.
Okay. Ms. Johnson, I did not get a response.
So,
Um,
and I was
response?
just going to jump into that, Judge. Hang on one moment here. Sorry, it's Grand Central Station here all of a sudden. There. Let me make sure this is off. All right. Hang on here. So sorry. Got it. So this is the thing, Judge. This motion was originally scheduled for May 10th, and May 10th I was on 120.
right. So I got the fact that it was rescheduled and set up for now.
But it wasn't rescheduled, Judge. Per
Wasn't?
Judge Bryant, she indicated that she was going to just set it for an evidentiary hearing and that there wouldn't be a hearing. So when
Oh,
my client,
okay. I
so
didn't
my
know that
client-
I did not know that she made a ruling on that then, because that's about the same thing I was going to do. Is she going to do the hearing then?
well, that's what she said, but
Okay.
I said I don't believe there was a basis for a change in parenting time, but
Well,
she said,
I reviewed what was placed on the record last time. There was some hesitancy by Miss Moore to make the agreement, but she agreed to it, and I did place on the record that if anything is happening badly, then we'll reconvene the hearing. Somebody may file the motion, and that was said on that day as we were taking the proofs to enter the document, because there was a hearing scheduled on this with me, and as
Gotcha.
such, you guys placed a settlement on the record. Ms. Moore was a little hesitant to do so because she did indicate that there had been some very poor communication from Mr. Doc. So I did admonish him to watch how he talks and watch how he communicates with her. But if there were any problems with parenting time, somebody may file a motion. So that was reserved in that same thing. I will note that when you sent in the order, that neither party signed it, even though it was an agreement on the record. So there's no signatures on that document either. But it was what was agreed to by Ms. Moore then. But again, it was hesitantly done. So if judge has granted a hearing, then the judge can do the hearing.
got it.
That's
May
a
I-
piece. That's a piece I did not know.
Okay, and Judge, she was not on the record. I just walked into her courtroom, indicated that I would not be there, and then I conveyed that there would be an evidentiary hearing to Miss Moore and my client, and then my client, while I was out. So this is the other thing, Judge. The parties, the order that you're talking about, Miss Moore, after I provided it to the Miss Moore for signing.
Right.
She did not want to sign it, so I submitted it under the 7-day order.
Right. Yes, I know the procedure that happened, but like I said, it was kind of reserved to review this. And at this point, if the judge is granted a hearing, the judge is granted a hearing. There's nothing I'm going to be able to do.
I haven't had any hearing information.
This is the first I'm hearing of it, Miss Moore, myself. I didn't know anything happened on the last date, on May 10th. I thought this was adjourned to this date. So I thought I was hearing a clean motion. I am not. It seems like the judge has reviewed this, and I will send it back up to the judge for the hearing. Okay. So that's news to me. That's all I was going to do too, is grant a hearing to see what's going on, and basically to see if it was necessary to change the order or to keep the order in place. I'm not saying that the order is going to go away completely, but I was going to grant a hearing on how to proceed further in the best interest of this child.
Understood.
Okay. All right.
Your Honor, may I ask one question? Under the 7-day order, my understanding with no objections filed by Miss Moore, that became the order.
It is the order. It is in place.
All right.
I was just noting for the record that it was an agreement that was hesitantly placed on the record, that neither party did actually sign it. You did appropriately. It's an appropriately entered order. They've been following it, I'm assuming. It just, according to Miss Moore, it's not been going well. And yeah, if her complaint is true that he took this child to the hospital or doctor without her knowledge, or that's not a good thing on his choices, especially when the court admonished him to be very careful how he proceeds. But the judge is going to do the hearing, so good luck, everybody. I'm sure the judge's office will be getting a hold of you.
I was going to say, we get some type of paper mail.
You'll get a notice. You'll get a notice.
I will follow up with Judge Bryant as well, Judge, but I want to make sure you're aware. It was not during a hearing that the judge told me that. She was she on some of these things she can do without oral argument. She can just, pursuant to Court Rule MCR 2.119, she can just, subsection E, she can say, look, I'm dispensing with oral argument. I'm granting a hearing. I've read the motion. Thanks. We'll see you at the hearing. Got it. All right. Good enough then. Thanks, Judge.
Take care. All righty.
Bye-bye.
Take care, everybody. Okay. That was news.
Yeah.
I'm like, okay.
All right, we can do Carpenter versus Carpenter.
Especially since Judge sent it down to me. There was a note on it. The judge sent it down to me. Sending you this one only because you had the motion on 510 that they want reconsidered. And I'm like, I don't think we did a motion on 510.
Well, it was assigned to us, but then it was adjourned.
Oh, okay.
So I think that's just what they were talking about.
Oh, okay. See,
it was adjourned because
I thought it was adjourned
because Ellie Johnson couldn't be present.
Yeah, I think
that's all that the clerk saw. And so like, oh, I'll just give it back to them. Anyway, we can do Carpenter versus Carpenter.
Good morning, Ms. Webb. How are you doing?
I'm doing good. How are you?
Hey, it's Friday morning. It's motions.
Yes.
I'm doing. We won't say well or poorly, but.
You want me to ask you at the end of the day?
We'll see. Normally I'm spent by about 11, but anyway.
Yeah, I can imagine.
All right. Miriam, did you connect, ma'am?
Yes, I am. Can you hear me?
Yes, ma'am. Who's with you?
This is my good friend, Nancy Schlad.
Okay, Nancy, welcome. You may sit next to her, but move the camera so I only see you. Just like in the courtroom, I should only have the parties on camera. Relax. You can stay there, Nancy. Just don't be on camera.
Get out of here, Nancy.
No. You can always have support in the courtroom. You can bring the posse if you want. They just have to sit in the gallery. So that's basically where I just put her. Thomas, can you hear me?
Yes, I can.
All right. Welcome to all of you. All right. Let's go on the record in the matter of Carpenter versus Carpenter. This judgment has been brought under the collaborative law process. But I will take the proofs. Miriam, you were listed as the plaintiff in this matter. So I will put both of you under oath and take testimony from both of you. Well, actually, Thomas, your job is just to listen. I'm going to take most of the testimony from Miriam. Ms. Carpenter, please raise your right hand.
Yes, sir.
All righty. Miriam, you filed a complaint for a petition for a consent judgment of divorce back in February of 2024, along with your husband, Thomas, correct?
Yes, sir.
And all the allegations of that petition were true and accurate when you filed it?
Yes, sir.
And they remain true and accurate to this day?
Yes, sir.
And you were a resident of Kent County in the state of Michigan for at least 6 months prior to filing that document?
Yes, sir.
And you were married to Thomas by a person authorized to perform marriages.
Yes, sir.
And there's been a breakdown of that marital relationship to the extent the objects of matrimony are broken and irreconcilable.
Yes, sir.
You want a divorce. Okay. And you presented to this court a judgment of divorce that you have signed and you're willing to abide by, that you believe to be a fair and equitable division of your marital assets, debts, and all issues of your marriage.
Yes, sir.
And you are not currently pregnant.
That'd be a miracle, or a mistake, but I am not pregnant.
Miracles happen, but mistakes happen much more often. So,
That's true. I'm sure you see it.
No, I have. There's
I
some,
know.
there are many of these that some people come in and say they are, and then we have to stop the divorce proceedings because we got to figure out who the deaf father is legally. All right, Thomas, I told you had the easier job here. You heard that testimony?
Yes, I did.
True and accurate, sir?
Yes.
And you've signed this document and you're willing to abide by it.
Yes, sir.
All right, Ms. Webb, any questions?
No.
All right, in that case, I do find, by and through that testimony, that this court has jurisdiction because this is where you live, and the proofs are sufficient to enter the document. So we'll sign this and get this processed. We'll get it to your office, Ms. Webb, and that way you may distribute it. So
Perfect.
have a great
Thank you so
morning,
much.
everybody. Take care and stay safe.
Thank you.
Nancy, take care. Thanks for being here. Thomas, you
Thanks.
should have had somebody with you too.
Yeah.
Yeah.
All right, take care, everybody.
All right. Goodbye.
Bye. The motion is very simple and very straightforward and pretty much necessary. Miss Van Eck, do you have any questions?
My only issue with it is I can't afford to pay for half a DNA test. I know who the dad is.
Okay.
He's the one who has questions about it.
Right. And typically what we do is in DP cases, it's the father who pays for the DNA test. If it comes back and he's not the father, he gets reimbursed.
Okay.
That's what the prosecutor would have done.
Okay.
Okay. Plus it also, if I make each party pay half up front, I've known people not to pay their half and then it never gets done. So I think they're under $100 now. So I'm going to grant the order, and if you can send that to the officer, and he pays it and reserve the right to have reimbursement in case he's not the father.
Okay.
Any questions?
Just two quick things, Your Honor.
Sure.
First one is just to briefly correct the record as to something defendant indicated.
What's that?
My client doesn't have any question and has tried to get this done for quite some time.
And forgive me, it might be an attorney doing this, Ms. Van Eck, because I practiced, I did 10 years as a divorce attorney, and I always told my clients to get a DNA test. It's always easy for an attorney to guarantee who mom is. It's easy for the medical staff.
Yeah, I get that.
But under
in
the law. Yeah, I
told him before my son was even born that if he wanted a DNA test, because he asked me for one, I told him I have no issue with that.
Right.
I also asked him if he wanted to keep it out of the courts or if he wanted it in the courts. Yeah. He told me he wanted it in the courts, so that's what I'm going by.
And that's fine as well. Now, I did have one case that was awful. Both parties were somewhat drunk when they engaged, and both of them remembered parts of it. And she swore up and down that he was the only person that could be the father, and the DNA came back and he was not. So it does happen, and that's why attorneys. That's why attorneys are cautious. So sometimes the attorneys jump in here and say, "No, we're gonna get a DNA test just to make sure."
He asked me before my son was born for a DNA test, and I told him I had no issue with that.
No problem. Well, I'm going to order it. I know what the
results are going to say.
Yeah, I'm going to order it, and I'm going to order him to pay for it. And if it comes back that he's the father, no reimbursement. If he's not the father, you'll reimburse in total. I mean, that's what the court's going to do. My other question is this: I have a scheduling conference with you guys. Mr. Raddick, should I just send this to the front of the court for custody, parenting time, and child support?
I was just discussing that as a likely outcome, and that would be much simpler for my client, as having to file a motion once the committee is established.
And, it's going to take them a few weeks to get this. So what I'll do is I'll send it to the front of the court in maybe 2 or 3 weeks. That way it gives time for the DNA test. And if you could send the DNA test to the court once it comes in, that way we have it all.
Sure. So you're going to do an administrative order for that portion?
Correct. And because DHHS is involved, because the prosecutor was going to bring this motion, but you circumvented it, which is fine. I'm going to waive the fees because of that.
Okay, appreciate it, Your Honor.
All right.
Is there a specific testing site that the court refers to, or
normally DNA Diagnostics does a good job and they're cheap?
Okay.
Because they have labs in many places, and I think that's who the prosecutors use. Plus, you need the they do a good job on the chain of evidence.
Okay.
All right.
I'll get that order in shortly.
Right, and work with Miss Van Eck to make sure that she can easily get the DNA testing, and it's just a cheek swab anymore. There's no blood tests or anything. So,
okay, that's good. I don't like my son being poked anymore. He already has.
Yeah, he gets poked enough. Yeah, I'm sure. But neither one of you have to get poked. They'll just take a buccal cell test. All right, off your cheek. All right. So take care, everybody. Have a good morning. So motion granted.
Bye.
Thanks a lot, Your Honor.
Anytime. This is her husband. Okay, because this is the number she gave us for the court, and she can't connect, so I was calling her directly. Yeah, if you go take her phone down to her, that way we'll have a audio connection. No problem. Okay. All right, I'm taking off the headsets. The other way. So it was her husband that answered.
Okay.
He's taking the phone down. He had her phone. So I don't know what she's on. All of a sudden my head looks really small after I took off
The headset gives you some extra space that's not covered by the background. Yeah.
Hello, can you hear me? All right, let's see if I can relax. Let me put you on speaker. All right. Now, let's do a test. Rebecca, say something, Miss Kershaw, and Miss LeVay, can you hear her?
I can hear you.
Okay.
Perfect. I can hear her.
Okay. All right, so let's go on the record in the matter of Kershaw versus Ramirez. Miss Kershaw, I've read your motion. There's not much I can do about it. At this point in time, that bench warrant was issued in November. You did not cure the issue of how much you owed in child support until March. It was cured on March 6th. It took a few days to get the warrant rescinded. So it takes some time for the paperwork. So you were arrested on a valid warrant for a valid reason. I will also note that you have not made any child support payments since the entry of that. And you are still, you're about to be held in contempt again if you don't show up for the next hearing. So another bench warrant will be issued if you're in non-compliance. So I don't know how I could give you relief, even if there was any relief I could give you. So
it really honestly was a huge miscommunication.
There wasn't much miscommunication. You paid what you needed to.
If you would let me speak for a second and explain myself. I had changed my address and closed out a P.O. box in Nuevo County, and they never finished. Something happened in the process of their changing my address. So my mail was being withheld at Nuevo County post office, but I was still receiving parts of my mail, but not all of it.
Okay.
And so I never got these notices until honestly the last week of April. When I had contacted the front of the court, I talked to them and they told me, I said, I'm not going to be able to make any payments until March 6th.
Okay.
And they told me not to turn myself in and to wait because I was going to pay it, but I had to wait to pay it.
Okay. And you paid it, and the bench warrant was rescinded. It just took some days to get that rescinded. So when you were, I don't know why you were arrested, but they brought you in on a valid warrant once they caught you, once they got you for whatever they got you for. But again, you know, all of that is beside the all of that is beside the point. You're still owing about $5,263 in child support payments, and none have really been made.
So you're still non-compliant with the child support. So there's still an issue here.
Then I'm not lying. I'm struggling, man. And I'm starting all over again.
Yeah, I understand. So do a lot of payers. It's not easy for anyone, but I have to treat you the same as I treat any payer. So at this point in time, I'm afraid any relief is denied because I have no relief to give you.
Well, I don't understand how it's a valid warrant if I already paid
You were in
the bond and I paid what the warrant wanted. So I paid it
warrant
off.
was valid.
And it was 3.5 weeks later
So
when they arrested me, and I already had an email stating that the warrant had been cleared. And if you don't want to give me the money back, or at least put it towards my child support or something, to like, I was wrongfully put in there when
and I probably would do that if you'd been paying child.
The warrant had stated me to do so.
And I'd probably do that if you were compliant with the child support in general, but you're not. You haven't made any payments, not since March.
I don't have a job right now, and I had a kid. I just started over in a whole new county and a new place, just got a divorce, and I'm starting back all over again. And putting me in jail, it set me back, and it cost my ex-husband a day at work because, you know, he had the baby, and like, it shouldn't take 3.5 weeks to process somebody's payment and put a piece of paper in the system to clear a warrant. And unfortunately, that happens a lot to these people.
It also shouldn't take
done about it, so you guys don't keep holding us people back.
It also shouldn't be a problem for the warrant being issued in November and it takes 4 months to make a payment.
I wasn't getting their letters and stuff, and they had the wrong
new child
phone
support
number.
new child support was ordered and needed to be paid. All right. Motion denied. I'm sorry. All right, no problem.
Would you like me to submit a very brief written order?
I'll put in.
Okay, I appreciate that.
Okay. I guess she left, and we'll call the other case, and I'll make the same ruling on that. That way there is a
record.
Take care, Miss Spencer.
You as well. Thank you.
I would love to work with her if she had made any payments whatsoever. All right. On the matter, we're going to go on the record of the matter, Kershaw versus Waters. I take it we don't have Mr. Waters present.
That is correct.
Okay. That case, neither party's present. I will note that we just had a hearing with Ms. Kershaw on another matter identical to this one. She has left. She did not appreciate the ruling of the court. I can't blame her, but I also have problems with people that are non-compliant with any court orders. So in this matter, I've read her motion. She's asking for relief because she was arrested on a bench warrant for her arrest for non-compliance that was issued in November. She was non-compliant. She stayed non-compliant through March, and she was arrested while the warrant was being processed to be dismissed. But it sounds like another warrant will be issued shortly because she's still non-compliant. So in any event, that motion is denied as well.
Good morning, Ms. Tran. Can you hear me?
Next.
Next,
Yes, I
we can
can.
do Tran.
All right, welcome. Okay, we are here in the matter of Tran versus Tran. I'll note that Mr. Tran is not present. This is a request to waive the 6-month statutory waiting period. Ma'am, is there any emergency? Because at this point in time, we don't waive this without what's known as exigent circumstance, something that requires the waiver of the 6 months. Otherwise, we've got to deal with child support, custody, parenting time, all of it. This is a divorce, potential property. So waiving the 6 months is not something the court readily does. There's a process to go through here. But, you know, the examples I used to give are if somebody was taken off to Afghanistan or being deployed and they wanted the divorce before they, you know, both parties wanted to separate and get it done, or somebody has a prognosis of an illness of some kind that we might need to get this done before that happens. But other absent exigent circumstance or some emergency, which is what that means, the court does not grant a waiver of the 6 month. Okay.
I understand
So
that.
yeah,
Yes.
so I have to deny your motion at this time and let this go through the normal process. Okay. Are you and Mr.
Okay.
Tran in communication? I realize that it sounds like he's moved on.
Yes.
So do you talk with him at all?
No, not at all.
Okay. So you may file the appropriate paperwork as necessary to proceed in this case. Okay. So I don't know if you're talking to a lawyer. It appears you got the paperwork from the Legal Assistance Center. So the process has been explained to you in the documents that you purchased from them. Okay.
Okay.
Follow that process and good luck.
Okay, so I just have to go.
Yeah.
So okay.
Yeah, I have to deny it at this time because it's going to have to go through the entire 6 months. Him having an affair is not enough to waive the 6 months.
Okay.
All right. Good luck.
Okay. All right. Thank you.
Dale, don't thank me yet. Thank me when you get it done. All right. Take care of yourself.
All right. Thank you.
Yes.
All right. Bye-bye.
Bye.
Bye-bye.
Sorry, I was getting
Okay.
coffee.
No problem. Miss Canfield, no problem. Did you get the coffee? So let's do
I
something.
did.
Let's
I
do
did.
something important before we start, okay?
Heavens, yes.
Yes. I don't want to talk to anyone until they've had their caffeine.
I hear you.
On some days I'd love to give them an Ativan on top of it, but I miss those days of working on a psych unit where I could, we were able to give 0.5, 1 milligram or 2 milligram doses of Ativan to the person as we were doing their intake. So I'd love to have 3 little bowls in the courtroom, like right on the wall. And it used to be a white, a blue, and a pink pill. As people walk in, if they're agitated, just take one of the red ones. Thank you.
All right.
All right. Mr. Lozano, did you connect, sir?
Yes.
Okay. All right. We are here in the matter of Strahota versus Lozano. I will note I've read the motion. I did not receive a response, Ms. Campfield. Is there? Because I also rewatched the judge's hearing. The judge was very clear. It's not 30 days that the judge gave you. It was 3 weeks. Ms. Campfield, you yourself noted that it needed to all get turned over by April 19th. The judge was given a short leash on this one.
Correct, Your Honor. So the issue being that with respect, first I did file a response. So I wanted the court to be aware.
I kind of figured you did, but as of yesterday, there was no response registered.
I have not received a response either.
Yeah, so there was no response because I was actually at the courtservice yesterday. There was no response registered as of then because I double checked because I kind of figured you would want one.
They were served on Wednesday.
Okay, so please, what is the response?
Well, basically, with respect to their allegations and paragraphs 1 and 2, we admitted that.
Right.
Yeah, paragraph 3, we denied that and said that the court ordered discovery to be exchanged by the parties and a hearing to be set on the matter on a date that was not a Friday motion date, and that the hearing had yet been set.
But after rewatching the judge's hearing, that was conditioned on you turning over certain documents within 3 weeks. And on these circumstances, have any of those documents been turned over? According to this motion, they have not been.
The documents have been turned over, albeit they were late. So
Ms. Bernal, do you have the documents and when did you receive them?
This week, she sent it over, I believe, at the end of the day on Friday. So I saw them on Monday morning when I came in. And what I received was unsigned other than by her party. It doesn't make any sense. I responded with follow-up questions and some of the documents I couldn't open. So I followed up and asked for additional information and some clarification, and I got no response.
Okay, well, I don't know.
What was turned over? Because it looks like there needed to be some documentation about the loan that was to the parents. There were some questions about the fact that the loan was done in 2014 or 2015. The parties weren't married until 2019. There was no attachment of the loan to the house. There is no indication that it was to the house. Did you find documentation that attached it to the house?
Yes. So my understanding, what I provided, and I emailed this on May 17th, and I kept a record of that email.
Yep, Friday afternoon.
Correct. And It was a contract for deed that covered a loan regarding the sale of the property at 4776 18th Street Southwest, which was their marital home. And that it indeed was signed by my client. And then there were 2 checks that were written on that loan for payments to Custom Carpentry, who is the one that provided that loan by the plaintiff. And
Custom Carpentry provided a loan?
Correct. So here's what happened. Mr. Lozano's parents owned Custom Carpentry.
So that,
and instead of him having to take out a mortgage loan or refinance a mortgage or anything of that nature, they provided him a home loan through the company that needed to be paid back as a contract for deed. That is what was provided.
Okay. And
council that specifically laid out amortization schedule. And then we attached proof of 2 payments.
How much was this loan?
It was $105,000.
And how many payments were made on that loan?
It was to commence as of January 1st of 2015, and payments were made consistent. How many did you make, Mr. Lozano? I don't want to state out of turn on that.
I don't know the number, but it was monthly from 2015 on until we sold the house.
All right.
So how much was paid down on that?
So the remaining balance.
I'll get to it, Ms. Brunel.
The remaining balance was $70,000.
$70,000. Okay. Yep. At this point in time, there was a time limit given by the judge that had been exceeded by almost a month. So I'm going to grant the motion to dismiss this. You obviously, because she sent it to me, I'm not exactly sure why, since she's the one who made the order, but I'm afraid the non-compliance with the discovery, that's outside the timelines. I'm going to grant the motion to dismiss. You will obviously have the 21-day appeal period to object to that, Ms. Camfield. The judge may deal with that on 2.119 or not. We'll see. But I don't think it's appropriate at this time after reviewing the arguments that were given at the time in front of the judge. The judge realized that you applied for this like just within the year to overturn this judgment. So you already delayed it. And then that's why I think she did the strict timeline. But I'm going to grant the motion to dismiss at this point in time. This judgment needs to be solidified and done. All right. Have a good morning.
Thank you.
There's unjust enrichment to the plaintiff then. I'm just going to state that.
Well, there may be unjust enrichment, but the unjust enrichment should have been argued prior and not waited and delayed for so long and then delayed again by your client in trying to argue something that was a unilateral mistake, not a mutual one. And even under contract law, that's not a reason to overturn the judgment.
Well, right? It was a default judgment, one in which he did not.
Yes, I know. Like I said, he didn't have any input. That went on for quite a few months before that was entered. That didn't even. So, I mean, now the divorce has been going on since this was filed in 2022. We're in 2024. And no, at some point, the judgment needs to rest.
And he did consent to the judgment. He signed it.
Again, if he signed it, that's even worse. So I didn't even notice that part. I just assumed it was a default. All right. Take care, everybody. Good luck.
Thank you.
Yeah, if they wanted that perfected, they should have perfected that lien. Anyway. Next,
we can do.
How's everybody doing this morning?
All right.
Good. Enjoying the unusual Michigan weather because it's actually nice outside.
Yeah, I don't think it's going to stay like that for the.
It's Michigan. It won't. Come on. This is one of those few states where you can get yeah, you can always get all. This is the one state where you can get all 4 seasons in 24 hours.
I know.
Yep.
But that's what's enjoyable about it.
I don't know about that.
No, I don't know, man. Michigan weather is crazy.
Well, it just means yard work at this point. And the white stuff that's
doing some of that on Monday. So
That white stuff floating in the air is what I'm allergic to. So
Me too.
yesterday
Same.
my allergy meds were not kicking in, so I took a Benadryl. 40 minutes later, I took a second Benadryl, and then 2 hours later, I was in a Benadryl fog. Boy, hi. So anyway, Mr. Banyan, did you connect, sir?
I'm here. Sorry about that.
No, that's quite all right. All right, let's go ahead on the record of the matter of Vistowski. Now, Arthur versus John motion to transfer venue. And I think the process at this point is that I don't believe that Michigan has jurisdiction any longer. I think Tennessee does have jurisdiction, but I don't think I can actually just transfer it. I think somebody has to file a case in Tennessee, and then the Tennessee judge generally contacts the judge in Michigan under the UCCJEA, and Michigan probably would 90% grant the transfer to Tennessee. But you have to have a case open in Tennessee, because we don't just transfer and then the case is in limbo. So there needs to be a case opened in Tennessee. But once that's done, I have no doubt that the court will do this. Is there any movement on filing in Tennessee?
I've talked to Mr. Johnston about obtaining an attorney. We kind of wanted to get the feel of the court today before he retained a formal attorney there, and he'll go ahead and do that as well. I know that they can file there's a scale form to start the process.
Correct.
Too.
Right, and what they would do is they would adopt any judgments and stuff they would incorporate into a Tennessee format.
Right.
But they're going to have to show that Tennessee has jurisdiction. So, Mr. Rossi, your argument would be then, because at this point he has the right to ask that, and the judges do have to confer on the UCCJEA issue.
Oh, so I would be able to object later, is what you're saying?
You might be able to object to Tennessee taking it, but she would have to object in Tennessee if Tennessee is willing to take it. Tennessee could reject it outright. I doubt that they will. If the child has been there more than 6 months.
Well, I don't think he has.
Okay, that's what your argument is, but I said if, because Mr. Banyan has indicated that he's been living there for quite some time, correct?
Well, we just got some school records this morning that the child just enrolled on April 22nd, right when we had our hearing last time.
Oh, so. Well, again, so yeah, the limited somebody would file a limited jurisdiction to challenge the jurisdiction in Tennessee then on that filing. So that's what would have to happen, because he has the right to file in Tennessee, and then it would be his job to prove that the child's lived there. If you have records that show that he hasn't, that's going to be a problem. But I remember that this is all about parenting time, and I was like, I wanted the correct venue, right? Because I wasn't sure that we had it anymore. So that would be the correct way of doing it. File in Tennessee, and the court will. I can't necessarily grant the motion outright, Mr. Banyan, because again, you have to follow the procedures of the UCCJEA. The judges have to confer.
Okay.
All right.
And I'm assuming that puts her on hold for anything until that happens again.
Do we have any idea of giving her any kind of connection, Mr. Banyan?
The concern is
phone call.
Yeah.
The concern is that it's been in excess of 5 years. I
understand, but I mean, at least phone calls or Zoom or something.
I think I'd like to see it go through a therapeutic setting first, just because I don't know how this minor is going to react. To not having any contact with mom that he can remember ever. So
right. Is the child in counseling in Tennessee, Mr. Johnston?
No.
I'm working at getting him set up with that right now.
Get him set up with that, and then you need to inform Miss Arthur who the counselor is, and allow Miss Arthur to have contact with the counselor. Let's get some counseling set up and see if we can get that going. That way it can be done therapeutically, Mr. Rossi. That way we've got something moving where the child currently is, okay? So I will order the counseling. That order I will grant, okay?
Right.
But the counselor's in Tennessee, so I'm not doing anything that's what my fear was is setting up something here and then everything being wrested from us.
Right.
So.
Okay.
All righty, Mr. Banyan, I'll grant an order for counseling to begin. So if one of you who wants to prepare that order.
I can.
Okay, prepare that order and make sure that your client, then put in there that the client will have contact, both parties will have contact with the counselor to assist in getting the child acclimated. Because eventually, I'm sure Tennessee has similar rules. They don't have the same rules, but similar rules to us that parenting time is probably presumed to be in the best interest of a child. It's just got to be done correctly. And it has been a long time since contact. And we do this, no offense, but we do this a lot of time when people come out of prison.
Yeah.
They haven't seen the child in quite a while and the child doesn't know them. But we do get it going.
Okay.
All right. Take care, everybody. Good luck. Hearing for 3 months later. Thank you. What's up?
Yeah,
Why
I was
the delay?
actually I was in the process of, I just started a new job. I was in the process of trying to earn some money so that I could hire legal counsel.
Okay. Well, that would be a good idea. But the objection is still standing and we need to get an order entered. And the only way to do that at this point is to grant you a hearing on this. So you'll be granted a hearing. It's going to be your burden, so you're going to have to go first. You'll be treated as an attorney if you don't have one. So you'll be given an opening statement, then you'll be calling witnesses. Evidence does not come into the court except through a witness sworn in on the witness stand. You don't just hand the court paperwork. The paperwork's got to go through that sworn in witness. The paperwork's got to be identified, what it is, how it's relevant, and then it's marked as an exhibit and entered, and that's when the court will look at it. Okay?
Okay.
Once you've presented your arguments, obviously any witnesses that you call, Mr. Keeler or Mr. Crow will be able to cross-examine those witnesses. Once you've presented all of your witnesses, Mr. Keeler or Mr. Crow, because Mr. Keeler is stepping in for Mr. Crow this morning because he was unavailable. So then on behalf of Ms. Pimental, witnesses will be called and you may cross-examine those witnesses. Afterwards, you may rest the case and the court will make a decision. That can take a day. I've had these take up to 6 days in trial. So we'll see where it's at and what proofs are necessary. But you've objected to the front of the court. I'm assuming somebody's going to call the front of the court evaluator. Obviously we're going to need to know, looking at the child support, I'm probably going to need tax statements for the past 2 or 3 years. And W-2 employees are always easy. I just need the most recent pay stub. But it looks like you are self-employed or have been for a while, sir?
No. I work in the tech sector.
Right.
And I was employed and then was let go and then re-employed. So it's been a tough job market, but never self-employed.
We're gonna need to have documents as to why you lost the employment and what that was and what the pay was. Was it a 1099 type of situation?
Nope. Everything in my entire life has been W-2. Yeah.
Okay. In that case,
large companies.
It might be easier then to see what those are. All right. So.
And I do have them all.
Okay, Mr. Keeler.
First of all, I would just like to note for the record that our office was not served as was required under the court rules, which is 2.107B1. I think we will be filing a motion for summary disposition based on 2.116C3. I don't think an oral motion for that will be sufficient.
Okay.
So we will probably be pursuing that. I will leave that to my successor counsel. I would also like to note as well is that in the notice of opportunity to object, it says a valid objection contains a written statement specifically outlining reasons for objection. Mr. McNamara simply stated
that it's inaccurate information used in determining parenting time and support.
That does not seem very specific to me. So I would say that.
Well, since I have not read the full report, I don't know.
Right.
You may file that successor motion.
Mm-hmm. I guess I would also. I apologize. Sorry.
No, that's okay. Go ahead.
I guess I would ask that the court require Mr. McNamara to amend his objection to comply with that directive, that his written specific reasons for his objection.
That would probably be wise, Mr. McNamara, to know exactly why you're objecting to this. The generic, if it's, specify why you think it's wrong and why it's not appropriate, and then do serve that on the attorney, because that attorney has the right to dismiss your entire objection based on inaccuracies. Okay. So, but at this point in time, I'll grant a hearing. I will discuss with the judge whether the judge will take this or whether I will. And a motion for summary disposition may put it in the judge's hands. So we'll see. All right. So have a good morning. But other than that, at this point in time, I'm granting the hearing.
Thank you very much.
Pending further action.
Thank you, Your Honor.
Thank you.
Okay. Thank you.
And to have some concerns about the attachment is an understatement. The other, I guess, issue that the court should know is, despite the fact that Mr. Burns has been on notice that this hearing where we're requesting a finding of contempt and a return to a personal protection order, the message is similar to what we attached in our exhibits. Personal messages, not child related, continue unabated.
Can you respond to the different numbers that your client has allegedly used?
That my client has used?
Yeah, according to the response that your client has contacted him from differing numbers.
She hasn't, Your Honor. My client had she had one phone. I think she had one phone, her traditional phone. But and then at one point she may have had a disposable phone. But the reality is, these multiple numbers, the proof of those multiple numbers is a screenshot of Mr. Burns' phone where he assigns names to that incoming number, and he can assign a name to any incoming number. In other words, much of the proof he shows doesn't show a number. It shows
contact information is coming from the phone that receives it. In other words, if I get a call from a number, my phone may recognize that number, and if I have it listed as someone, that's who it shows up with on my phone. Right. So you're correct. It's assigned by his phone. It's not saying who is the incoming call. It's not an identification. It's just an acknowledgement that that number is normally from that person.
Well, unless Mr. Burns intentionally assigned.
Well, and that's what I'm saying. It comes from his phone, so it's inherently not necessarily her. I think the defendant's response also indicates that she admits to some of these numbers.
Well, she admits to, no, not some of the numbers. She admits that, first of all, that one of the children, when her phone was unlocked, hit a speed dial number, and she explains that. And
right, I saw that as well.
Upfront about it, yeah.
Yeah. So, well, here are my concerns. And Cindy, Ms. Rathburn, I've read your response. What do you care to add to it? Because I've got some statements to make, but I thought I'd give you an opportunity.
I appreciate that. Well, a couple of things. This is not set up for contempt. My client was not personally served. There is not an order for contempt. So we're not dealing with contempt proceeding at this point in time.
Well, so inherently it's a request for a contempt proceeding. The show cause can't be done this morning. You'd be granted. You're going to be, and I am going to grant him a hearing on that.
That's what I was.
Yeah, you do get a hearing on that where everybody will be personally done. Now the question is, do you want that hearing in front of the judge or in front of me? We'll talk about that momentarily, but continue, Ms. Rathburn.
All right, thank you. And I would also point out that the attachments from Ms. Sheber's side of things didn't have dates or times on any of the text messages that she.
I understand. That's why you get the hearing. That's why you get the hearing.
Yeah. No, Your Honor. If this hearing is about my client contacting Ms. Sheber, then I also have violations of Ms. Sheber contacting my client. And if you're going to go on the premise that a 2-year-old, because that's how old their child is 2, was able to access her phone and dial up my client and speak to him twice.
Doesn't Ms. Sheber have another child?
There's 2. There's like a 1-year-old and a 2-year-old.
Oh, so they're both very, very young.
They're very, very, very young. And so the credibility on this stretches quite a bit to say that this child can do that.
Well, and that's why the hearing, you'll have the right to defend.
All right.
My questions became that the difference between the two versions of communication is his are somewhat questionable because they're not about the kid. They're about, why are you doing this? What's going on? You know, basically they're accusatory. The communications that you've attached from your side, Ms. Rathburn, tend to mostly be about the kids and how to move the case along, not about how to get back together. So I'm going to grant a hearing on a show cause to be decided by either one of you, whether you want it in front of the judge or in front of the referee. But as to the PPO, as was reserved, she has the right to reapply for the personal protection order, Mr. Sherland. I'm not going to grant a personal protection order. The judges have to do that. So she has the right to reapply based on what she's got.
Well, what I really wanted to do in the order of operation, Your Honor, was deal with these messages and get a ruling from the court that these messages, rule on the messages.
Well, I'm not going to make a ruling on the messages without a hearing because of what Ms. Rathburn just did say, which is there's not dates and stuff. So there's going to need to be testimony about when these were sent and how they were sent. But as well, I also have before me, I've got a scheduling conference statement, and it looks like it came from Ms. Rathburn. Did you have an opportunity to review that, Mr. Sherland?
I signed it and sent it back.
Oh, you did? Okay. So Miss Benedict is going to be the mediator?
Yes, Miss Benedict is fine.
Okay. That's all I wanted. I just wanted to make sure because I'm filling that out.
Yep.
Contemporaneously with this.
No, Your Honor, my thought was that if the court, whether it's you or whether judge, finds that the messages were in violation of the restraining order, then my client would apply for the PPO on that basis.
In that case, you might want to have this hearing in front of the judge because the judge issues the PPOs, the referees do not.
If that would be the more efficient way to do it.
That probably would be the more efficient way. But, again, as I warn people, I realize that even if he's found in contempt, there's a cost benefit analysis here. We're trying to get these parties done in this case. So, while there's a lot of foolishness that occurs and very poor communications back and forth, use your time and money wisely on things that may or may not assist the parties in the future. So, but the hearing is granted, just use it wisely. And yeah, we'll do the show cause in front of the judge. Okay. That way you can request her to reinstate the personal protection order if she makes the right findings.
Your Honor, just so you understand my methodology here, I'd really hope that simply filing this motion would be enough of a warning that the communications would stop. Unfortunately, the proof show that that's not true.
And that's like I said, I'm concerned a little bit about the way your communications from your client are, Ms. Rathburn. And the ones from the mother, even if they are inadvertent, tend to be predominantly about the children and contact and getting the case over with. Those are reasonable. I want to get back. Why are you doing this to me? Those lend more toward a harassment. They're not about the kids. And they're not about getting the case completed. So, but also we'll have a hearing scheduled in front of the judge on a show cause on this, and good luck to both of you.
Your Honor, do you need an order from me then?
You might want to contact the judge's clerk to get a time and date for the show cause hearing.
Okay, so just get the time and date and get
a time. Yeah, and yeah, I'll try. You can I'll try and explain to the judge's clerk why I chose the judge, because she's the one who issues PPOs. So, all right.
Can I ask a procedural question?
Sure.
Okay. Procedural question then. If I'm going to allege that she violated the no contact order, which I have the ability to do, would I have to have a separate motion then? And
no. I think this can go both ways. I mean, I think yours is more of a defense, but
I would still have that.
You could. Yeah, I guess it's a show cause potentially against both parties for violation of this.
Right.
Yeah, I have no problem with my client's action, Your Honor. So
okay, thank you.
So I'll send an email to judge's clerk and I'll copy Ms. Rathburn on it asking to schedule.
Okay.
All right.
Good to see you all. Take care. I'll get the scheduling order. I'll get the scheduling order in, and hopefully Ms. Benedict can schedule them, and maybe you guys can bring this to a conclusion.
All right. Thank you. Have a good holiday weekend, everyone.
Good luck. All of you enjoy the weather. Take care.
Yeah. Okay.
Bye now.
And don't hurt yourself in yard work.
How I was yesterday.
Your paperwork is everywhere. Katie here. So, no, that's not what I'm looking for. Where did I? Okay, where did it go? There it is. All right. So I wasn't sure which one we wanted to start with. Casey's here, it looks like. Is Catherine here?
No, she's at work. She could not. She is put in for the day off.
No problem.
That'll
happen. Yes, unfortunately, this should have been in front of Judge West, except for the fact that you're asking for an entry of an order that was done by me, therefore.
Why Judge West?
Because this is his case.
This is Brian.
Oh, is it? Oh, did it get
No.
reshuffled?
It got reshuffled long ago. The problem was is we were in the middle of everything. We were in the middle of everything when the shuffling happened.
Got it.
But he's leaving the family court anyway, right?
Uh-huh. Yeah.
So it'll get shuffled again.
Well, whoever gets elected, this one's going to be by election, so. It's okay. I just got one to go to the judge because they're going to request a PPO be reinstated, and I'm like, referees don't initiate PPOs. So, although we did find out last week the new ERPO law, they were going to make the referees the on-call people for that, and I'm glad that one of the judges that was helping write the law said no. They had equated it to the fact that since we're on call for removing of children for neglect cases,
that you could do that.
That we could just add that to the list.
That seems like a whole legal nightmare if people don't agree with it now, right?
Well, it wouldn't matter. They were going to write it into the statute.
Oh, I see.
So this was going to be a statutory authority. Because they decided that it should be handled by the family court because the process that we go through for dangerous situations like removal of children and abuse, neglect, and domestic violence and all of those things, those same procedures are being put in place for ERPO. There's got to be the same protocol. Whereas in the criminal court, you're innocent until proven guilty. There's a difference in how the burdens would be done. So they figured the family court has more experience with that type of stuff. Casey, did you connect? Casey? That's why we were talking.
He's actually on a school trip, so he might not be able to actually speak.
Well, he keeps muting and unmuting. I just want to make sure he can hear us.
Yeah, I can hear you if you guys can hear me.
Yeah, okay. That's what we were waiting for. That's why we were kibitzing until we got you connected. All righty, ladies and gentlemen, let's go ahead and go on the matter of Rife versus Rife case. I'm not sure which one do you want to handle first, the order or the taxes?
The order may be easier to handle first. I did not receive a response to that motion from Mr. Carpenter, so I'm not sure if he has objections to that proposed order.
I do.
Oh, you do? I don't have that one.
No, I have objections.
Oh, you do? Okay.
The court has some questions.
Fair enough.
Yeah, I've got some concerns about it. I didn't really want to handle getting the order entered this way for reasons I can go into later.
It doesn't matter. We need an order. I was dumbfounded. I issued my opinion on November 1st, and we still don't have an order from that. I'm okay with number one. I did not change custody at all. Number two needs to be deleted. Going through the factors, and I'm going to request that all the factors be deleted because I placed them on the record, and 3 of them that you have in this proposed order, Ms. Steffes, are wrong. Because there are 3 of those things that I did not have enough testimony to weigh at all. So they are not weighed equally. They were not weighed at all. Because there was not sufficient testimony for the court to weigh on the 3 of the 12 factors. So that has to be stricken. Number 3 looked like it was in compliance with what I ordered. So that's fine. 3A, 3B looks like it's what I ordered. 3C is what I ordered, so that's fine. I had a question about holiday time because this does not help the parties at all. I don't know what to do about that because I'd ordered that I said I wasn't dealing with parenting holiday time. Again, there was no testimony to do so. But I note that it's in some agreement that they had made, a mediation agreement. Is this what the mediation agreement states?
Oh, that I do not know that, honestly.
Well, then holiday time is to be as previously ordered.
Okay.
And if there are problems, then the parties may bring an issue with that. Or if you want, I will issue my order of holiday parenting time and send it to you to be placed in this.
I think
Mr.
that
Carpenter, I think you already have a copy of that.
I do have that from another case, but I think that
Yes.
the holiday parenting time that we're starting with is, based on what the parties have been doing already.
Yeah, and that's, I said I didn't have any testimony about holiday time. That's why I didn't change it. So I was leaving it as it is. So holiday time should remain as previously ordered. Okay.
And do you want me to take out the exhibit attaching?
Just put in holiday time. What do you mean?
Because my proposed order just incorporated their parenting time, the holiday parenting time schedule from their judgment of divorce. That's all it is.
No, that's why I was asking, because I couldn't find that. So the parties, it says the parties shall exercise holiday parenting time as they mutually agree. That's what the previous order says?
No, it says.
No, it's a specific schedule.
That's what your order says.
It does. And it says
it should just state, I didn't get an exhibit A. Oh, wait. Yeah, but because the judgment of divorce, the exhibit A has nothing about holiday time. It just notes that it's pursuant to an attached, an attachment of the mediation agreement, but then doesn't have it attached.
Right.
So I have no idea what the holiday time is. So just note that holiday parenting time is as previously ordered.
Okay.
Because I think if you put in there that it says as mutually agreed, I don't know what the previous order says. So just leave it as previously ordered, because I did not touch it.
Okay.
As to number 5 is what I ordered. Number 6, you will strike everything after split that was ordered in the court is not changing the tax deduction split that was ordered in the party's judgment of divorce. I made no finding on whether it was part of the property settlement or not.
Okay.
I made no finding that it was non-modifiable. So that part of the sentence has to be stricken. I didn't get I don't have copies of the UCSOs that were attached. I'm assuming they were okay, Mr. Carpenter?
The UCSOs
how many UCSOs? I didn't get, in my motion, I did not get copies of the UCSOs that I had ordered.
Yeah, well,
so I'm assuming that their number 7 would be fine.
I took the calculations that you had done, Your Honor, and put those into the UCSO.
Yeah. So I'm assuming that, you followed those, and that would be fine. 8 is something I ordered as well. 9 is something I ordered. And as to dicta, Mr. Carpenter, no, I did make a finding that I was not changing the tax exemption because it was requested. And again, since I had no testimony about it, I was not altering the judgment of divorce.
I understand. Well, that's the point I was trying to make, was that you weren't making a ruling on it. But that's okay.
Right. I just left it. I left it, and I said it will stand. Yeah, I said it will stand. So the judgment speaks for itself, and that will deal with in the next motion. Number 9 is correct. Number 10 obviously is the statute. Number 11 is also the statute. So is number 12 and number 13. All of their orders are fine. With those corrections, the court would enter that order.
Okay, I will do those today.
As to the other, as to the other motion, normally the court has always dealt with unclean hands about having child support arrearages and tax exemption usage with the fact that we don't allow the party to use the exemption if there is a child support arrearage on December 31st. What I have discovered is that policy no longer exists. So obviously the IRS changed its ruling. There used to be an IRS circular, which is how they give their opinions, like an attorney general's opinion in the state of Michigan. IRS releases circulars. There was a circular released about 20 years ago that indicated that if you condition the uses of a child support tax exemption on anything, then the tax exemption becomes unusable by the non-custodial parent. So the idea was the front of the court had a policy that said, hey, we want arrearages paid up. So if there's an arrearage as of December 31st, the tax exemption is not usable. That policy no longer exists. And what I found is that in the past few years, people have been actually adding that as a condition in the judgment. Now, as to past practices, there is no way I'm touching 2019 and 2021. I'm not going back that far. So no, as to any reimbursement for taxes in 2019, 2021, I'm denying that. 1, unclean hands. 2, I'm not having money coming from where the children have been predominantly living. We dealt with all that at the last hearing. As to the 2023 taxes, Mr. Carpenter, my ruling on November 1st said that I'm leaving the judgment in place. Without any conditions on that, she was allowed to use those exemptions. He was on notice that they were hers, not his. By
But
court
Your
order.
Honor, that's not entirely correct, because the parties subsequently had a child support modification in 2018 that awarded the exemptions to Casey in the UCSO.
No, they did not award the Casey. They put them in the calculation of child support, which may have been incorrectly done. But the court order is the court order. The judgment will be enforced, and that's what I stated on November 1st. So he was on notice that she was going to be using them. So for 2023, the remedy is this. I'm not having money come out of his pocket either, Ms. Steffes. This motion was brought by the state of Michigan. This motion was not brought by either party. So Ms. Smith-Lowe represents the state of Michigan through the Kent County Prosecutor's Office, who brought this motion. Is this a DHHS case, Ms. Smith-Lowe?
This is a DHHS case, Your Honor.
Okay, so we are here to ensure that the benefits that the children are getting under your care, Mr. Morgan, continue until further order, okay?
Yes, sir.
All right, so that's why we're here. So I'll let Ms. Smith-Lowe proceed with the motion, and then I'll ask for any questions from you. I'll note that Ms. Webster is not present. This matter was set for a hearing at 9:30. We gave her some time. It's now 10. I'm sorry, this matter was set for a hearing at 10:30.
Can I fill you in why she's not there?
When we get to that, I'll let the prosecutor put the motion on, and then yeah, you can add that input if you'd like.
Yes,
all righty, Ms. Smith-Lowe, please proceed.
Thank you, Your Honor. We're asking for entry of the judgment of support as proposed, Your Honor. As the court is aware, this case was filed on or about November 21st, 2023. Service was proper on Ms. Webster in the Kent County Correctional Facility on December 4th, 2023. She responded on January 9th, 2024. It has since been released, and a pre-hearing conference was scheduled on April 10th, 2024. That pre-conference hearing, pre-hearing conference was attended only by Mr. Morgan. At the time, he was in between jobs. He thought he would get another job, and we were gonna connect later. We ultimately spoke on May 9th, and I was unable to again reach Ms. Morgan. No. The calculation for 2 children.
I was gonna say, yeah,
no, Ms. Webster.
I'm sorry,
Webster.
Ms. Webster. My apologies.
That's okay.
My apologies. We're used to the roles being reversed. My apologies. The calculation for 2 children.
It does happen.
The calculation for 2 children is based upon Mr. Morgan's actual income of $16 an hour, 35 hours a week with 365 overnights, and Ms. Webster's imputed income of $10 an hour at $10.33 an hour at 35 hours a week with no overnights, 1 other minor child. That calls for base support of $147, ordinary medical of $30 for a total of $177. The uninsured medical split is 61% plaintiff and 39% defendant. We're seeking a referral to friend of the court for custody determination because the AOP language is ruling at this point.
Yes.
And we got a call from Mr. Morgan yesterday indicating that there were custody arrangements already in place. But my review of the friend of the court file indicates that there was a temporary order entered in a DC case that granted him temporary a temporary order that was by Judge Bryant on October 21st, 2022. And then a referral to the friend of the court was also made by the judge, but the entire case was dismissed for no progress. The friend of the court evaluation was terminated October 21st, 2022, and the entire case was dismissed for no progress in March of 2023, making any custody orders ineffective. So we're asking for a referral to friend of the court so that Mr. Morgan can have some type of custody, legal custody in place.
I think I may deal with that this morning. I think this one may be more obvious than that. Mr. Morgan, what's your input on this? And understand that your income is irrelevant to this proceeding because it's 99.8% based on her income. I could double your income or cut it in half and it's not going to change the child support. It's based on the potential income that we're using against her. And did you freeze?
I understand that, Your Honor. I'm not trying to press for any more money or anything like that. I'm basically, I just want to have full custody of my kids because she, Your Honor, right now, she just went back to jail again. Okay. And she's not being a good person for her kids at all, not setting a good example, you know, and the things that she is doing.
Okay. All right. All right.
Sorry,
okay.
Mr.
Let me drive this one for a minute, okay, Mr. Morgan?
Yes, sir.
Okay.
What's going on, Rebecca?
Referee, I think you're freezing.
Somebody's freezing because I'm not seeing nobody.
Yeah, the referee's freezing. So we're gonna wait for him to come back.
Am I free?
Yes, sir.
Okay.
Yeah, you're freezing, referee.
Okay, is it me?
It's you.
Yeah. All right. Okay, then it's me. All righty. Well, then I'll tell you what. I'm going to stop my video. But before I do, Travis Morgan, please raise your right hand.
All right. Sorry about that.
Do you swear or affirm? That's okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in giving testimony?
Yes, Your Honor.
All right. I'm going to zap out my video. Mr. Morgan, how long has this child lived with you?
My kids have lived with me for over 3 years. And I've had full...
Okay, so you've basically been taking care of these children for 3 years?
Yes, on my own, Your Honor.
Okay. What involvement has she had with either of these children?
The only time she has involvement with those children when she calls, I will allow her to see them, but she's supposed to be, as court ordered, was supposed to have her own transportation to pick up the kids and drop them off as of March.
All right. And when was the last time she saw the children?
She saw the children about 3 weeks ago. I allowed them to go visit her and I dropped them off. And it wasn't good when I picked them up.
Has she ever made a doctor's appointment for these children?
No, Your Honor.
Has she ever helped pay for any of their care? Clothes
no,
or
Your
food?
Honor. No, Your Honor.
Neither one of these children are in school yet, are they?
They are both in school. I have them full time in school with me.
Okay. Okay. How are they doing in school?
Great.
Okay. At this point in time, Ms. Smith-Lowe, instead of jumping through some hoops that are not necessary in a case like this, I will note that the court has already awarded him in a contemporaneous case, even though it was dismissed, temporary sole legal and sole physical custody. Noting that prior order of the court as a res judicata, I will also indicate that it sounds like the custodial environment is with the father. These children look to him for their care, custody, and supervision. The mother is not involved. She is in and out of incarceration. She has very limited contact. She's made no medical decision. She would need clear and convincing evidence to overturn such a decision. Therefore, just from the knowledge of them being with them, under factor A of the best interest factors, that's the father. These kids look to him. Under factor B, the custody and disposition of the parties involved to give these children love and affection and care. Again, that goes to the father. He's the one who's been caring for them for the past 3 years without any help or consideration. He's also the one that has the state subsidies assigned to his household. Therefore, that care and custody is with him. The capacity and disposition of the parties involved to provide the child with food, clothing, and medical care. Again, that factor would go with the father. He's been doing it all along. Looks like he's going to be doing it into the future. She's incarcerated temporarily again, which means the child support order is appropriate. If she gets assigned to prison, Mr. Morgan, we'll probably have to take the child support to zero.
Yeah, that's like I said, I'm not worried about the money, Your Honor.
Right.
I want her to get right, Your Honor. You know, she just got incarcerated on the 19th of May for assault on a police officer and resisting arrest on a police officer. And she was under drugs. So
Okay.
Your Honor,
All
and
right.
I don't want to interrupt the court. I just wanted to let the court know that that original temporary order back in 2022 gave the parties joint legal custody and gave him sole physical custody.
Oh, okay. Well, I'm still going to note that she's not had any legal decision-making authority with these children. So again, the legal custodial environment and the physical custodial environment from his testimony and from indication on the record and the court filings indicates that it's really been with him all along. The length of time the children have lived in a stable, satisfactory environment, that's with the father. I don't have any testimony on the permanence of the family unit because he's got a girlfriend, obviously, so I don't know who lives in his house, how many other children there are. I've got no testimony over moral fitness. So there's some concerns, obviously, from what he just stated, still under oath, that she has some drug issues. So there may be some mental impairments that may affect her ability to take care of children. At this point in time, I'll note that the reasonable preference of the children I'm not going to take into account at this time, simply because of the nature of this hearing, and it'll be reserved if she wants to file for anything in the future.
Yeah,
I'm not going to weigh factor J. I am going to note that if she's assaulted with police officers, there's kind of a violence situation going on under factor K and factor L. So I'm going to find that the father should be granted sole legal and sole physical custody, not the mother in this case, because that's the reality. So that's what I'm going to do. I'm going to grant the father to have custody, legal and physical. That can be placed in the order. Ms. Smith-Lowe, I realize you don't generally deal with legal, but I'm ordering it. So yeah, now that I've taken testimony and like I said, I've reviewed the file, this is mostly to maintain the children's state benefits. But the reality is she's not involved. If she wishes to be, she may come in and eventually address the court to determine whether any custody change or parenting time should be granted. All right. Any questions, anybody?
I have a question, Your Honor, regarding whether I don't see that she is incarcerated in Kent County.
She's in Newaygo.
She's in Newaygo.
Yes.
Okay.
As of the 19th of March, of May.
Should this be should this be a zero order now?
Yeah, it probably should be because of her incarceration. But if she's ever released, then this is the order that will go back into place. So that should be put in the order. Okay. If she's released, then this order goes back in place.
I'll do a zero order for now with the deviation to what was proposed.
Correct. All right. Any questions, Mr. Morgan?
No, Your Honor. I just also wanted to state that she also has another daughter too that her mother has full custody of too. So I just wanted to put that in mind too.
No problem. All righty. I'm going to come back on the record and see if I'm going to visually come back on the record. I've been on the record the entire time, but in any event. All right. So that'll be the ruling of the court. I'm granting the prosecutor's motion with the addendum of what I've just made findings on in court under oath.
I'll make those adjustments and submit this under,
all right.
You sign, Your Honor.
Thank you, Your Honor. You have a good afternoon.
All right. You all have a great day. Take care.
Yeah, thank you.
Okay.
So we don't have no reference on that. Thank you.
Yeah, that's why I'm like, when it's a reality like that, why are we going to make all kinds of people jump through hoops when I can take testimony and find by clear and convincing evidence that he's the custodial parent?
Yeah.
And she would have to overcome it by clear and convincing. So just a quicker way of doing it.